So again, thank you all for joining us this morning. I want to thank you also, everyone submitted such great questions ahead of time, which we were able to use to plan this presentation today. So we got tons of questions. And if we don't get to your question today, please feel free to reach out to our department. Marlon's also going to post some contact information during the presentation. So if we don't get to your question, or if you think of something afterwards, please reach out and we'll do our best to connect you to the right answers and resources. During the presentation today, if you have any questions, primarily clarifying questions, please put them in the Q&A window. If there are any new questions, we'll do our best to answer those. But again, please reach out if you don't get an answer to your question today. So now I'd like to introduce our presenter, one of SFPL's favorites, Marlon Schultz. Marlon's an attorney with a JD from Golden Gate University School of Law. She's licensed to practice law in Texas and California. And I'll let Marlon tell you all a little bit more about herself. So thank you for being here today, Marlon.
Thank you for having me, and thank you to the San Francisco Public Library for putting this on. I'm just going to share my very hastily put together PowerPoint presentation. Let's see here. How are we looking? Good. Okay, fantastic. So again, thank you to the San Francisco Public Library for hosting the first ever Ask an Estate Planner Q&A session. As Jonathan mentioned, my name is Marlon Schultz. I am a trust and estates attorney licensed to practice in Texas and in California. I'm very happy to be here with you today. And this next slide just shows you a little bit about, hold on a second. Hold on. Over here, hold on a second. There we go. Technical difficulties the first time around aren't surprising. But essentially, this gives you a little bit of information about who I am as an attorney, but who I am as a person, I think, is actually more important. The reason why my office exists is because I lost a family member who was very dear to me, who knew that they were going to pass away and who did not have any estate planning documents to them whatsoever. And so it created a lot of problems for the year immediately after his death. And so that's essentially what my law office is here for, is to make sure that those kinds of things don't happen again. And so we're really big on planning. We do handle probates, but we really like to drive it home and handle those kinds of situations ahead of time. At the bottom of this screen, you'll notice that there's a QR code. You can click that code or scan that code on your phone if you have a specific question that you want to ask me. That'll give you 20 minutes on my calendar. There is no charge for that. The goal here is to get you to leave with a good sense of what you should be doing. And if you didn't, then you can always ask me later on, absolutely free to San Francisco Public Library members. So in terms of all of the questions that you guys put together, which were so good, it was very interesting. We're just going to start off with what it means to get started with an estate plan. And so some of the questions surrounded topics about how do you begin? What are the first steps and the kinds of necessary information that you should put together? The first step, I think, is actually consulting an attorney. I know that there are a lot of people out there that really enjoy the DIY space when it comes to crafting legal documents. And we'll go into, the pros and cons of that here a little bit later. But the reality is attorneys go to law school and they have working knowledge of the law as a result of that. And people who are not trained in the language of estate planning and probate, you don't know what you don't know. And so sometimes plain language in very complex legal documents can create more confusion than you think. And so my first instinct to tell you is, if you want to begin, the first thing that you should be doing is talking to an attorney. And frankly, a lot of attorneys, they will give you free consults. They're not above doing that. A lot of them just want to get you to talk to them. And that's a really great way to do that. Another thing that you may want to think about also is, the kind of necessary information that you need to put together. You obviously want to put together a list of your beneficiaries. You want to make sure that those beneficiaries are reasonably identifiable. You want to make sure that if you have property that needs to be discussed in that conversation with your attorney, that you have the information in front of you so that you can easily pull that up. But you basically want to be able to give the attorney that you're speaking to a very broad perhaps, 25 to 30,000 foot picture of what your estate looks like and who you're trying to protect. That's really key. You also, you also need to think about, life events that trigger that need. And so when we start talking about, those kinds of life events, really what we're talking about are marriages, births, deaths, divorces. Okay. Sometimes it can be the acquisition of property, whether that be something that you purchased or something that you inherited. It can also be, unfortunately, we've all sort of gone through this already, but it can also be world events as well. So, for example, we all lived through the pandemic. And believe me when I tell you, there was a mad rush to the estate planner attorney's door to get estate planning documents put together. So life events can absolutely trigger that need. Also, changes in the tax code. That may be a reason for you to start consulting with an attorney about changes, necessary changes, or perhaps an initial build of your estate plan. And just FYI, the tax code is going to change at the end of this year. And I think that Congress was voting on a tax package not too long ago when Cory Booker was giving his historic 24-plus-hour filibuster the other day. So just be mindful of the fact that the tax code does change quite frequently and sometimes not by the people who should be drafting it. So definitely keep that in mind. We also had a lot of questions about, how do you go about choosing proper agents? And this is, I have to draw back and say the best way to pick an agent is to think about the what ifs, okay? You need to start thinking about, who exactly you would want to have governing your property in the event that you could not do it. Who do you trust? Who has good financial acumen? Who knows to get an adult if they don't know what to do? And I know that that sounds very elementary, but you would be surprised how many people think, if I don't know the answer to this question, I am not capable of reaching out to somebody to get help. That is probably not the person that you want putting in charge of your child's trust fund if it really comes down to that. So my rule of thumb when it comes to choosing agents, you need to have somebody with good financial acumen. Inevitably, they will be handling your property, whether that be through a durable power of attorney or whether that be through the provisions of your trust. So you want to make sure that they at least understand what basic math is, okay? And I know we don't really do this anymore, but have they heard of balancing a checkbook? Do they know basically how to keep some sort of plus and minus system, some sort of credit and debit system in terms of a financial ledger? Do they know to get a CPA if they don't know to do that? So that's number one. Number two, you're going to want to make sure that you pick somebody who has really good skills under pressure. When somebody passes away, when somebody's incapacitated, that is a really stressful situation. And so the person that you want to choose needs to be somebody who can handle that situation with grace and somebody who can handle that situation knowing that, they need to have a cool head in order to make good decisions. Somebody who panics is going to make really bad decisions. That's just the fight or flight, adrenaline-induced system of response that we as humans are hardwired with. And so finding somebody who can really take that deep breath and say, you know what, I'm gonna handle this. I'm gonna just take a deep breath and I'm gonna, work my way through a very stressful situation. I'm gonna invite the people that have information for me to use into that conversation. That's your person. The other thing that I want to actually guard against is, sometimes nominating your best friend or somebody that you've known for an incredible amount of time, just because they're friends with you under a very particular set of circumstances does not mean that they will make good successor trustees or guardians of your children or agents under your durable power. Don't pick your drinking buddies. That's also a really good rule of thumb. Basically, anybody who you suspect has an issue with substance abuse should not be somebody who's picked to be any kind of agent under those kinds of documents. We've also had a lot of questions about what are the basic documents that everybody needs. And I'm going to go through this at a really high level. But the reality is, at a bare minimum, you should have a will. Now, in California, I recommend that people go the extra mile and get yourself a revocable living trust because California probate is a 12 to 18-month process. It is a statutory fee based on the total value of the estate. It is not cheap. And sometimes it can cost tens of thousands of dollars depending on the value of the estate. And if you have a will, you are guaranteeing that you are entering into that system. So If you can avoid that, get yourself a revocable living trust and sew it all up in one nice tiny package. You're also going to want to have a durable power of attorney, which is a document that governs non-trust assets during periods of incapacity. And we'll talk about why that's essential in terms of that juxtaposed against a trust. We'll talk about that here in a minute. But basically that allows somebody to handle your assets in the midst of an incapacity event. And that's really also very important in terms of an overarching plan. Thirdly, on that list, you absolutely need to have a healthcare directive. I can't say this enough for my soon-to-be divorcees. The durable power of attorney and your healthcare directives are probably the two most important documents that you're going to want to sign if you're going through a divorce. Because under the California statutes, your spouse is still your spouse until you're divorced. And you definitely don't want those people making healthcare or financial decisions for you. Certainly not while you're incapacitated. I feel like waking up from that is going to be a really bad day. So get those done. If you're going through a divorce, again, that's a life event that triggers a need. You should be getting those done. Last on the list, and this is sort of, the sister to the healthcare directive, you're going to want a HIPAA authorization. This is a document that allows people to access your medical records in the event that they need to. And it's a really important document because really what we're looking to do is, make sure that if there is a medical condition that we need to make a diagnosis or a decision based on, your attending physician has the necessary records, possibly from your general practitioner, maybe from a specialist that you've been seeing. But we want to make sure that those HIPAA authorizations are in place. Another really good reason to have a HIPAA authorization in place is actually when we start getting to be elderly and it's clear to the people around us that maybe we should not be managing our own finances. I know that's hard for a lot of people to swallow, but the reality is if people don't have access to your medical records, it's very possible that somebody with dementia could end up making really life-altering decisions inadvertently simply because they just didn't have proper care. And so again, having that HIPAA authorization is just a really, really important document. So just to round it off, the list of basic documents that you're going to need as a Californian: a revocable living trust, a last will and testament, a durable power of attorney, a healthcare directive, and a HIPAA authorization. Okay. The next slide I want to talk to you about, and this is kind of what I alluded to before, was, the difference between wills and trusts. And this is a really great segue into that DPA versus trust conversation that I was about to jump into. You should think about your will as though it is a beautiful set of suggestions, but that it is legally meaningless until a court authenticates the document. So again, that document is basically just a document that says, this is who I am, these are my family members, these are where I want, these are the people that I want my things to go to. And all of that is fine, but until a court authenticates it, it really actually has no legal standing. Okay, it has literally no legal standing. The difference to that, though, is that a trust is something that is activated the moment you sign it. It's something that you should sort of liken to a contract, and it's a contract between your trust maker, which you sometimes call a grantor, and your trustee, which is the person who manages that property, and they manage the trust property according to the terms of the document. So in that respect, it's very similar to a contract in that you have a trust maker and a trustee, and the management of the property is done according to the terms of the document. Any property that's titled into the trust is managed under the terms of that trust while you're alive, while you're incapacitated, and after you've passed away. And in doing so, because it's held in trust, that is how it avoids probate, because it's already covered how that property is to be treated during the lifetime, during your life cycle, essentially. One of the benefits of the trust, again, is that it avoids probate. And I think I put a finer point on that just earlier, but it really is a great way to make sure that you do not spend 12 to 18 months in California probate, and that you're not spending tens of thousands of dollars out of your estate administering this property. That's benefit number one. Benefit number two is that, the administration of a will under a probate is court supervised, and those documents are part of the public record. And the reason why your probate is part of the public record is because people need to know if you have debt, what your assets look like. Your debtors have a right to figure out what exactly is in your estate so that they can get their claims paid. And I am not suggesting in any way that you should get a trust so that you can skirt your creditors. Believe me, they will find you. But it's more akin to just making sure that even if you do have creditors, the property is not open to the public sphere. The names of your beneficiaries are also not open to the public sphere. And you're keeping a lot of that potential for publicity at a minimum. You're also reducing your administrative costs. So again, that tens of thousands of dollars in California probate is not going to be what you're spending in terms of trust administration. Even for a mildly complex estate under a trust in California, you're probably looking at maybe $4,000 or $5,000, maybe a little bit more. But again, it really depends on the complexity of the estate. But again, your administration costs are lower with the trust. Your time spent in court is all but eliminated, assuming we, title everything properly. But again, I can't say enough about the necessity to have a trust if you have property in California. It's really very important to do that. And then obviously the next question would be, when would a will alone be sufficient? I will say this, that many California estate planning attorneys will actually refuse to draft estate plans that are will-based. And the reason why they won't do that is because, believe it or not, your beneficiaries may have a cause of action against the drafting attorney if the estate itself should have avoided probate with a revocable living trust and the estate was somehow squandered as a result of going through probate. And so it is very rare that you will find an estate planning attorney who is willing to risk their practice and their malpractice insurance to draft a will-based estate plan alone. That said, if you are going to go with a will-based estate plan, it means that you own no real estate. It means that if you do own real estate, it is on a transfer on death deed to a very specific individual who has survived you. That also means that all of your bank accounts are on pay on death. Again, that your beneficiary designations on all of your assets have been filled out correctly, and that you double check that the people that you've named have not predeceased you. And you do this every year. You also want to make sure that, again, that your beneficiaries are not minor children. That's another thing that you really want to look out for. If you are giving cash or real estate to a minor child, then that runs up against the Transfers to Minors Act. And that can mean sometimes, depending on the complexity of the estate, that can mean a guardianship over that property for those kids. So again, just having a will doesn't necessarily mean that you're not going to end up in court, even if everything is on a pay on death. So I just want to caution you, this is a conversation that is very nuanced, and it is something that you do want to have with an attorney, because again, only an attorney is going to be able to tell you, based on what I'm looking at in your asset portfolio, whether or not a will alone would be sufficient. So just be prepared for that. And in line with wills, let's talk a little bit about what a pour-over will is versus just a regular last will and testament, and how we go about funding a trust properly. So a pour-over will acts as a backstop, basically, to your trust-based estate plan. And basically what it says in a very shortened and very charactered way is, if I forgot to leave anything out of my trust, when this document is probated, whatever was left out of trust now becomes part of the trust property. So you are still going through probate. That's 100% a guarantee. But if that happens, that means that your only beneficiary is the trust. So the trust's beneficiaries are not in the public sphere. That's not part of it. And most likely the copy of the trust is also not going to be part of the public record. There is something in California, however, called a Hegstad petition, and that's Heegstad. And I know I'm butchering the spelling on that. Hegstad. And basically what a Hegstad petition is, it's a document that you file into a probate court that outlines the circumstances under which a particular piece of property or pieces of property was inadvertently left out of the trust. And it is sort of like a shortcut to getting that property placed in trust without actually having to probate a will. So just be prepared. That is, it's absolutely something that's out there. But again, only an attorney would be able to help you do that. That is not something that you can DIY. In terms of funding a trust properly, really what we're talking about in every single instance about funding a trust, we're doing one of two things. You are either retitling an asset in the name of the trustee of a trust, okay? Retitling an asset, or you are making changes to a beneficiary designation, okay? So you are retitling an asset, like you are titling an asset out of your name as an individual and into your name as trustee of a trust. So let's say your house, or your investment accounts, or let's say your I don't know, what's another good one? Some sort of financial account that's not a retirement account. We'll come to that in a minute. But anything along those lines, that is something that you would title into the name of the trust. Maybe an RV, maybe a boat, something like that. If you have the means, I suggest you do. But also in terms of changing beneficiary designations, the other thing that we want to be mindful of is the tax code. Certain assets should never be placed into trust. And those assets are typically cars and retirement accounts, qualified retirement accounts. So if we're talking about IRAs or 401ks, those should absolutely never be titled in the name of the trust. You get really poor tax treatment because anything that comes out of your name as an individual and into the name of the trust, you get hit with a 10% early withdrawal fee. So we will not be doing that. You definitely want to keep it in your name. And when you fill out your beneficiary designation, typically we want to put a spouse in the pole position in that primary beneficiary box, because again, the tax code gives us much better tax treatment when we pass our retirement accounts to our spouses. Secondary on that list can absolutely be your trust, but again, it's not retitling. We're just naming a beneficiary for that purpose. Also, let's talk about your cars not going into trust. And the reason why we don't do that is because what we're talking about are daily drivers. So your Honda Civics or your Toyota Priuses, or anything that gets you back and forth to point A to point B and back, that is not something that you're going to want to put in your trust. And the reason for that is simply this. If you get into a car accident and you look down at somebody's registration and you see that this car is owned by a trust, how likely do you think it is that the person who is injured is going to maybe try and exaggerate the depth and extent of their injuries because they think you have deep pockets? We want to avoid that. So when it comes to your daily drivers, those are not the things that you should put in trust. But if you have vehicles, let's say a classic car collection or an RV that's worth north of 150,000, or let's say a boat, those are all assets that should absolutely be going into your trust, and for the reasons that I've just specified. So I hope that cleared that up. But again, if you have any questions about that, anything specifically you want to speak to me about, again, that QR code at the bottom, just click that and you can get your 20 minutes with me. And again, that is 100% free for SF Public Library members. The next group of questions that I want to go ahead.
We had a couple clarifying questions
Sure.
in the Q&A. So just when you use the word property, does this mean only physical real estate or all assets, including financial?
Sure. So when we talk about property, we were talking about real estate and we were talking about tangible personal property. So that's like the things in your house. That can mean your investment accounts. That can mean anything that's not real estate. Real estate is considered real property. So property is the giant umbrella. You have real estate, real property here, and then personal property is basically everything else.
Okay. And then, and just let us know if you're going to cover this subsequently, but this is for someone whose parents don't own any property. Would you advise we should still do all the will trusts to cover other assets?
I mean, it's going to be a case specific question, but generally, yes, at a bare minimum, you at least want to have a will. If they're Californians and you were concerned about probate avoidance, then getting a trust would be better.
Okay, thanks. And then if you create these documents and then move out of state, do they all need to be redone?
Unfortunately, yes. And this is coming from somebody who practices in 2 states. I can tell you that you definitely don't want Texas law governing your California property. That can have some pretty dire consequences. So you definitely want to avoid that. So I do recommend that, again, if you're going to make the move and you're planning on putting down roots, then absolutely just go ahead and get them all restated. It's something that you can come back and revisit. If it's just going to be a temporary stay and you intend to move back, don't deal with that just yet. You don't need to do that.
Okay, thank you. I think, yeah, I'll let you know if we have any more clarifying questions.
Say we're only a few minutes in. Wow, guys.
Thanks everyone for your questions.
Okay, next up, let's talk about planning for special situations. We had a lot of questions on this. People are worried about estranged or excluded relatives. Let's talk about that. If you have relatives that you are worried are going to infiltrate your estate plan, or they are going to petition the court to, disauthenticate a will because they think that they were left out inadvertently, then my suggestion and what we do in our office actually is that we we mention those people by name, and either we give them a nominal amount, so that way we can say, no, you were in this estate plan and you only get $5. You can absolutely do that. It is petty. I'll be honest, it is very petty, but it does get the point across that this person was not forgotten, and that they have no reason to suspect that this was done as a result of dementia or anything along those lines. The other thing I recommend that, and this is something again that our law office will do, we will specifically state why. If this person is in the estate plan and let's say they received nothing, we will say exactly why, in our client's words, why this person isn't going to get anything. And the reason why we do that again is because we want to make sure that it's understood between all parties that the reason why this person was left out was valid, or at least valid to our client. And so we want to make sure that that's in there. So if there's any question in terms of litigation, it's pretty answered based on the letter of the document. Let's talk about excluded relatives. This comes up a lot when I see parents, young parents that are starting an estate plan, and maybe they don't revisit this until maybe 20 years later. And at the time they only had 2 children, and now there are 3, and they're all adults. Generally speaking, your testamentary documents, whether that be your will or your property management documents like your trust, they should say to my children. They should name the children that you have, and then include some language about adopted or after-born children in the document. There should be something that includes that. You really do want to make sure that as your family is growing, that again, this is a life event that triggers a need to have your estate plan reviewed. You really should be including those kids by name. And the reason why you want to do that is because I have had cases where people who were clearly not blood relatives or had any business dealing with this estate wrote into a court in the middle of a probate to say I should be considered an heir, and then my client had to pay for DNA testing to disprove the claim. You really want to avoid something like that. So again, you should be getting your estate planning documents reviewed every 3 to 5 years, and certainly for changes in life events that we showed in that first slide. But you really want to make sure that that's in there. If you have, again, intentionally excluded somebody and you've not made any mention of why they were excluded or anything along those lines, believe me, that can open itself up to litigation later. So it is so much better to be specific. It is so much better to use plain language in situations like that. I know that people worry about, well, what are they going to think about me? And, am I a bad person for doing it? I guess that's a moral and ethical dilemma for you to figure out. But the reality is, without simple, plain language, without an explanation, sometimes that can go really awry. So just be aware that that's sort of the trade-off. And by the way, you will have passed away at that point, so you typically will not have to face them about that. So just a little bit of humor, but that's the truth. Let's talk about long distance heirs and out-of-country assets. So you can give your property to pretty much anyone, anywhere in the world. Okay, so if you die in California and you've got a house and you've got a couple of cars and you've got furnishings and investment accounts or whatever, as long as your heirs are reasonably identifiable, they do not have to be sitused in California to collect any of the property in your estate. As long as they are named in your estate planning documents, as long as they are beneficiaries, named beneficiaries, you should not have to worry about anything along those lines. Where it gets a little tricky is if you have assets that are not sitused in California, whether that be in a different state, like say Texas or the other state that I practice in, or let's say out of the country. Let's say that you have, oh gosh, let's make it romantic. Let's say that you have an Italian villa. You should invite your favorite estate planning attorney to visit. That's rule number 1. But rule number 2 is, if you have property sitused someplace else other than where you currently are, so certainly in a different country, you are going to need to employ an estate planning attorney or the functional equivalent in the country where that asset is located to handle it. And the reason for that is because the US and other countries have tax treaties, for now, have tax treaties about how they intend to treat other properties in other states. The US tax code is designed in such a way that every US person is taxed on all assets worldwide. So even if the asset is not here in the US can tax you on that asset unless there is a tax treaty between this country and the situs country, okay? So you're really gonna wanna make sure that you understand exactly how that estate planning system works in that other country. There are countries that have forced inheritance models, meaning that you cannot write somebody out of your will, or that property has to be distributed in a very particular way in your family and you cannot alter that. You're going to want to know how that works before you go drafting an estate plan that you think is going to work. It may not. So that's, again, something that you really, really want to watch out for. The other kind of planning that we should really be talking about, and I think that this is probably more common to the group of people that are here today, are very specific situations for people who are single or who have no children, or for unmarried couples, people who have minor children, people with pets, personal property, and digital assets. And we're going to take this one at a time. So if you are a single person and you don't have any children, the number one issue that I see with clients that walk in my door is that they don't actually know where they want their things to go. And sometimes we'll be sitting back and saying, you know, it can go to charity, it can go to your nieces and nephews, anybody you want. And it'll take them a few minutes to sort of come up with a list. And many times they go with homework. And so, you know, just keep an open mind and know that you can give it to whomever you want. If you have a favorite charity, you can absolutely donate it. And so just make sure that you understand that, you know, at the end of all of this, it's got to go somewhere. And that's really what we want to make sure that we do, is we make sure that we have a very clear path and lineage as to where your property is going to go. If you are an unmarried couple, this can get a little bit complicated. Essentially what you're going to be doing, it's not that you guys can't put together your own trust. The two of you can absolutely put together a joint trust. You can absolutely do that, and just make sure that, you know, you're both on the same page with whose separate property is what and whose separate property is what, and have very specific language about where you want your property to go. Is it all to your partner? If it's not to your partner, do you want your partner to have, you know, I don't know, something like a life estate, meaning that they can use that property until they die and then it goes to somebody else? Any and all of that is possible, but you definitely need to be specific about it, and you definitely want to write that down. If you have minor children, you are going to want to make sure that you are not giving distributions to minor children outright in any document. And again, it's for the same reason that I mentioned at the beginning of this presentation. One of the biggest problems that we have is, you know, guardianships and conservatorships for minor children, because somebody like a grandparent named them as a beneficiary on a policy, and all of a sudden little Betsy has, you know, $50,000 in her hands, and she should not. Maybe she's 6 years old. Maybe that's a really bad idea. And so what you really want to do is you want to make sure that your estate planning documents speak to the fact that there are minor children involved, and have some sort of language in there that says that if any beneficiary is under a particular age, it's held in trust until they reach that age. In our office, we will not draft an estate plan for anybody under the age of 25, or I should say for outright distributions to people under the age of 25. And the reason for that is pretty clear. Your prefrontal cortex is not fully formed until you're at least 25. And let's be honest, even at 25, there are questions. Some of us do not make really good decisions even into our 30s. And so it's just really important that we put some brakes on those kinds of distributions. And we certainly don't want to give grieving 18-year-olds unfettered access to cash. So just remember, you want to make sure that you want to make sure that there's no outright distributions to minor children. You also want to make sure that you have a very robustly drafted guardianship nomination. Those guardianship nominations, I can't say enough about them, frankly. A good guardianship nomination should specify exactly who you want your children to be with and who you do not want them to be with. It should be sort of like the love letter that you leave behind to your kids that say, these are my educational aspirations for my children. These are the kinds of things I don't want them exposed to. In our office, we use a form that specifies access to firearms, access to social media, access to cell phones, the kinds of people that we want our children to meet with on a pretty frequent basis, if they're our friends or our relatives. Absolutely the people that we don't ever want them associating with. And again, we always put why. It's super important for your guardians who may not know why you don't want these people around your kids to know why you don't want these people around your kids. And certainly if there is a case file underpinning that prohibition, you're going to want to attach that as an exhibit. And that is really important, especially for divorcees who have divorced for cause. If there is a court order that says your spouse should not be around your kids and does not have any parental rights to those kids, you absolutely want to attach that as an exhibit to the guardianship nomination, just to make sure that if this guardianship nomination is ever contested by that spouse, you can point directly to that record. Very, very important information there. Let's lighten it up a little bit. Let's talk about pets and personal property and digital assets. So I know that San Francisco is a little bougie these days, and I love it, by the way. But we do have things called pet trusts. And I just want to get into this. Some people don't have trust for their kids, but they do have pet trusts, and I want to cover what that is. A pet trust is exactly what it sounds like, which is a trust that is set up for the care and maintenance of a pet. And it can be something that's short-term, long-term, however you want to term this out. And basically the same sort of rules apply. You know, if you want to give the person who has the care and custody of your pet $1,000 a year for vet bills, you can do that. If you want to make sure that the pet has access to a trust fund, and that the guardian of the pet can have access to this trust fund for the care and maintenance of the pet. I have seen and read ridiculous stories about people who gave everything to their animal. And I mean, I love my cat, but I don't know if he's a $5 million animal. I got to be honest with you. I'm sure he thinks he is, but I don't know that I would be that kind of person. But there are people out there that will fund a trust with millions of dollars just for an animal. And then there is a litigation about who gets to care for the animal. And surprisingly, sometimes that animal lives for much longer than it's expected. Sometimes because it's inadvertently replaced by another animal, but that's also a cool, fun story we can talk about at some point. But in terms of personal property, again, personal property, you're just going to want to make sure that if it has a pay on death designation, it's filled out. If it's something like, I don't know, like the things in your house, like your dishes or your, I don't know, like your dining room table or something, you've got heirlooms that are, sitting out there. You should have some language that says if it's an item that is unique or rare or expensive or all of the above, that it has a very specific home and that it's not going into a residuary where people can fight over it. That's also something that you absolutely want to avoid. Let's talk about digital assets. Cryptocurrency is a really interesting area of estate planning and something that I don't think a lot of people know about. Basically, you want to make sure that you are identifying your digital asset reasonably identifiable. If it's an NFT, if it's crypto, you better have keys, the public and the private keys. You need to be able to go back and reference that. Otherwise, you're not going to be able to transfer it to anybody. You also want to make sure that it's understood where the digital asset is being stored. So if it's in a hot wallet, if it's in a cold wallet, if you don't know what those are, you need to know that. But again, you just want to make sure that, again, the property is reasonably identifiable and that there is a clear lineage as to where this is going. And that, again, if it's crypto, you know what the public and private keys are and how it's housed. The next slide I want to talk to you about. And
Arlen,
Jonathan again. Okay.
Really quick, clarifying question. We had a couple questions just about registered domestic partners.
Okay.
So one, when you say spouse, does that include domestic partner registered as such in California? And then the other question was, with respect to domestic partners, are the tax implications as a beneficiary different than a spouse?
Okay.
That might be out of the scope, but
it's a little out of the scope. I'll be honest, we're not going to cover specific tax questions today. I can tell you that the guys behind registered domestic partners was basically before Obergefell, that there was going to be some sort of category of personal relationship that would be treated under the tax code the same way as a married couple would be without calling it a marriage, because that was verboten for the conservatives, and however historically that played out. So generally, yes, as a registered domestic partner, you should be getting the same tax treatment as a married couple. Okay, but that's not always the case depending on the state, and so that's why I'm thinking that that's a very specific question. But what was the rest of the question? I'm sorry, I kind of glossed over that part.
Well, the other clarifying question was just when you use the word spouse, does that include registered domestic partners in California?
In California, yes, because that is one of the states where you are treated almost exactly the same. It's virtually the same,
Okay.
Other than the name, basically.
Okay.
Okay.
Thank you. And I think everyone, thank you for your questions. If we're not getting to your question immediately, it's because it's likely going to be covered later in the presentation. So
Right.
Yeah, stay tuned. Thanks, Marlon.
Okay. And this next slide is very near and dear to my heart. When we start talking about whether or not you should DIY your estate plan or whether or not you should hire an attorney. That's I'm gonna just say it outright. Obviously, I have a profit motive. I'm an attorney. And I also think that we do it better than lay people because we've been doing this. This is our entire existence in the professional sphere, is to make sure that these documents are done the right way, succinctly, every single time. We get into a lot of trouble when they don't get done that way. We have malpractice insurance if something like that happens. And we have to keep up our continuing legal education annually. There's an annual requirement for that. So, it's one of those things where I'm like, there's a story, and we've got a little bit of time, so I'll tell the story. There's a story in law school that they teach you when we start talking about wills and trusts. And the story is that there was a farmer who was found dead in his field after being missing for days. And his tractor had tipped over on top of him such that the fender was resting right across his chest. He was basically buried into the ground with the wheel sitting on top of him. And before he died, he had the presence of mind to scribble something into the fender, something to the extent that, wife takes all, or wife takes nothing, or something to that effect. And he did not have a will otherwise. Okay. And so the probate court actually admitted the fender as evidence of a will, that this was his dying wish, that this was going to be the way that he was going to probate his estate, that his wife was either going to get something or not going to get something. And that constituted a will. Because it was possible, I should say, it was unlikely that anybody else had scribbled that on there. And so, the ascertainable facts as to whether or not this was reliably his were very good. And the fact that he had the presence of mind to do this beforehand. So they will admit something like that as a will. Do I think that you should wait until a fender is pressed against your chest to write out your estate plan? No, I don't think that you should do that. And I don't think that you should go to companies like LegalZoom or Rocket Lawyer if you have a complicated estate. I know that times are very hard for people, and I know that spending a lot of money on an attorney is sometimes really out of reach for people, and I 100% understand that. But I think the kind of money that you can end up spending in litigation later, or that your heirs will end up having to spend in litigation later, should be a deterrent, frankly. And if you know that you have a complicated estate, or even if it's not complicated, if you know that you have relatives that may fight over your things, this is not the pathway for you. I've actually had to litigate in a case where somebody produced a Rocket Lawyer will that was only 4 pages long, and after subpoenaing Rocket Lawyer to find out if this was actually their document, and they said that it wasn't, it was clear that this was a doctored piece of evidence. And you really don't want to find your heirs in that kind of situation if you can help it. So my first instinct is to call an attorney. If you have a plumbing problem in your house, it's probably best not to DIY it. If you have a structural problem, like a foundation crack in your house, it is probably best not to DIY it. Your estate plan should be thought of in the same way, because this is the foundation to you building your wealth, generationally speaking. Okay. We can either spend it in court, or you can give it to your heirs. It's up to you. So that's really my rule of thumb there. How do you find a good estate planning lawyer? I get this question a lot, and I always say that they should look exactly like me. They should be clicking that QR code to get a hold of me. I'm just kidding. Really what you want to do is you should talk to your friends and neighbors first. Believe it or not, your friends and neighbors are going to have either done their estate plan and had either horror stories or really good stories to tell you. Most people, when they have a good experience, they don't typically leave reviews. I know that sounds weird, but if somebody has left a negative review, you can bet that it was bad, because that means that somebody took the time to write it out. So I recommend that you go to your friends and your family first to find out who they've used, if they've used anybody at all, and then just do some basic research. Go to the state bar and find out if there have been any complaints lodged against that person. Go to their website and see if there are any 1-star reviews, or 2 stars or whatever. But just, and then have a conversation with them. Estate planning attorneys are not a dime a dozen. Okay. You will have some that have really good client side manner, and then you will have some that are just horrible to work with. And your instincts are going to be really good at picking out who is a good fit for you. And if you're going to be spending that kind of time and that kind of money with somebody, you're going to want to feel like you understand them, that they understand you, and that you feel like you have a connection with them. That's, I think, more important than anything else. And this is the kind of relationship that you want to keep over the course of time, because again, you should be revisiting your estate plan for major life events, like we discussed in the first slide, at the very minimum every 3 to 5 years. So that's essentially how I would go about finding a good estate planning lawyer. Are there affordable planning options? There are always affordable planning options. You can talk to, depending on how much you make or don't make. There are some really good legal aid societies in the Bay Area. Open Door Legal is one of them. I actually used to work with them back in law school, back when they were in the Bayview. The people that work there, Adrian Tirinati, I'm sorry, I'm mispronouncing his name because it's been 20 years, but he's amazing. And frankly, his staff is really all about caring about their people. So Open Door Legal is a really great legal aid program that I recommend for people who can't necessarily afford a San Francisco attorney. You can always talk to people about prepaid plans or payment plans. A lot of lawyers, again, realize that, forking over a few $1,000s to get a set of documents is not ideal for people, especially in this day and age. And so a lot of us, we work on payment plans. And if you're really great, you'll find an attorney that doesn't offer or offers a payment plan that's, no down payment, no interest. And those are out there, okay? A lot of lawyers really got into this because they want to help people and they don't want to see cost be a barrier to entry in terms of getting your estate plan done. So really do the time, do the legwork, find that person. And if they offer a payment plan, take them up on it. It's that simple. In terms of updating older plans, I do see this question a lot. I've had people walk into my office that have said, I haven't touched my estate plan in 20 years and my kids are now 30 and 40 years old. What do I do? Well, you update your estate plan. That's what you do. You can bet that in 10 or 20 years, the tax code has absolutely changed. So you were going to want to update your documents to conform to that language. I've got a set of trusts on my desk right now. They were drafted back when the exemption amount was 1.5 million per person. So this was like 2004, 2005. The exemption amount right now for the gift or for the estate tax is 13.9 million per person. I mean, that is such a swing in a very different direction. And I hope you all have that problem. But if your tax language is built for 20 years ago, it needs some updating. That is, you absolutely want to do it. And again, major life events, deaths, divorce, birth, purchases of property, inheritance. Those are the kinds of things that you really should be revisiting. And I know that people are like, well, my beneficiaries haven't changed and I'm just going to let this go. You can do that. It's a plan. It's not the best plan, but it is one that people tend to engage in. So just be aware, if you're not looking to update it, you can really have some issues. Another thing that people want to understand is if I have a revocable living trust, when do I amend that trust versus when do I restate that trust? And that's a great question. When you amend a trust, you are typically taking smaller pieces of the language out and substituting something else in its place. So for example, let's say that your father passed away and you found out, who your real friends were during that time. And so the people that you have listed in your beneficiary designation or your beneficiaries in your trust, that needs to all be revamped because half of them never showed up to the funeral. That's an amendment. That is not a restatement. That's an amendment. A restatement would be something more along the lines of, this is a 20 or 30-year-old estate plan, or perhaps you have moved to a different state. And so you've got a California trust that needs to be restated for Texas law. Let's say that the tax code has done a complete 180 and now you want to keep the name of the trust, but we need to restate the entirety and the distributions because the tax code has changed. That would be a wholesale restatement of the entirety. So that would not be an amendment. That would be a restatement. And that's generally how you look at it. Amendments are smaller changes in the document. Restatement is the whole thing. The whole thing is being taken care of. The whole thing is being redone. The next slide that I'd like to talk to you about is transferring assets and avoiding probate, because this came up quite a bit in terms of the questions that were being asked. And so it's probably one of the most popular topics that we saw in terms of this. And I am probably going to run over on time, but essentially, in terms of titling assets, when you have a joint tenancy, basically what that means is you have two people or more that are joint tenants in the property. And typically, if there is language that says with rights of survivorship, that means that the last person standing inherits the whole. Okay. And that is a legitimate way to avoid probate. Is it the best way to do it? I don't think so, but if you have 5 or 6 people that own one piece of property and they're all in agreement that the last person standing keeps it, then congratulations, you've avoided 5 probates with that property. But again, that's going to be a very fact-specific case study that you would want to do with your attorney. Transfer on death designations or transfer on death deeds are also a really great way to avoid probate. Basically, traditionally, you see this between parents and children, where you're basically saying, when I pass away, this automatically transfers to my children. That is a transfer that occurs outside of probate. That is another way that you can do that. I have seen it done where it will go to surviving spouse and then to children. I've also seen what's called a ladybird deed, which is something that says, I am going to make a present day transfer to my children, but I'm going to reserve a life estate, and that deed is 100% revocable. And so it's also another really interesting tool in the tool shed that we typically use in Texas, not so much in California. And also beneficiary designations. It's another great way to avoid probate. And again, simply by making sure that you've made your beneficiary designations clear, that they're updated, assets that pass on that, again, pass outside of probate. So that's another way that you can do that. You see that a lot on bank accounts. You see that a lot on retirement accounts. And some life insurance policies obviously are all life insurance policies are going to have beneficiary designations. The key here is just making sure that you have completed those forms. It's not uncommon to have an estate go through probate because of one asset. Let's say that a life insurance policy that was offered through the office never had a beneficiary designation attached to it, and all of a sudden somebody dies. Guess what? That's going to their estate, so that's going through probate. That's not how you avoid it. So you want to make sure that you're careful about that. We had a lot of questions about how to handle real estate, business interests, and retirement accounts. So in terms of transferring assets, especially when it comes to real estate, what I don't want to see people doing is gifting things to their children during the course of life, okay? You want to do this at death, okay? You don't want to give it to them while they're still alive. For one, you're making a completed gift, which means that the value of whatever you're giving them has to be reported on your income tax return. The other thing is you are going to lose the step up in basis for the portion of the property that you're gifting to your children. What does that mean? When you pass away, any property that goes to your children ends up getting a step up in basis to current market value. So let's say that you bought that property for $10,000. When you pass away, it's worth $100,000. But if you gifted away that property during the course of your life at a time when it was valued at 50, one half of that property going to that kid is now going to be stuck at $50,000 in terms of valuation for capital gains tax purposes. When you pass away, this other half gets a step up to current market value. And when your child goes to sell the whole, they're exposed on capital gains from the date of death to the day that they sell it on one half of the property versus the day that they inherit or the day that they were gifted this to the date of death on the other half of the property. So again, you're including capital gains, you're increasing the exposure to it. You can avoid that simply by making that gift after you pass away. And that's really the way it should be done. But yeah, again, that's a case-by-case basis. You've got to talk to an attorney. You should be talking to a CPA about that as well. How do you handle business interests? If it is not in your operating agreement, how you want your business succession to work, then you've got a problem. You do need to talk to a business succession attorney, especially if it's a family office and you've got some kids that are running the office and some kids that have nothing to do with it. The last thing you want to do is have this business interest go to your kids in equal shares so that they can fight over the management of it later. This is a really bad idea. Talk to a business succession attorney. If you have a business, you should have the money for a business succession attorney. That should be part of your responsibility as a business owner, is to gain or maintain that continuity. And so doing that, you've got to talk to the right people to get it done. How do you handle retirement accounts? It depends on the retirement account. If you've got a 401k or an IRA, it's termed a qualified retirement account, which means that your contributions to it are tax-free when they go in there. So basically, or I should say tax deferred, we'll use that, tax deferred. Which basically means that all of the money that goes in there, you're not being taxed on that. You're not taxed until you start taking your required minimum distributions, which at this time is 73 years old, okay? When you pass that on to the next person through a beneficiary designation, the first person that should be listed as your primary beneficiary is your spouse if you have one. And the reason for that is under the tax code, they get beneficial tax treatment, meaning that they can inherit that account and it continues to grow tax-free until they hit 73, if they've not already hit it. So again, that's a really important piece of tax information you should know about. Secondary to that, you should not be naming your minor children as beneficiaries on retirement accounts. Again, you do not want to give outright distributions of hundreds of thousands of dollars to grieving minors. It's just a very bad idea. So if you don't have a trust, you need to get a trust, because you're going to want to make sure that the trust governs those distributions to those minors. You're going to want to make sure that there are some breaks involved in making sure that they don't just withdraw everything, go to Vegas and cry their eyes out on the gambling table. Like, you really want to avoid something like that. And without having that kind of structure in place, it's very likely that they will misuse that money, and you really want to stop that from happening. Again, in terms of your IRAs and 401ks and naming your beneficiaries properly, just make sure that you have full legal names and relationships. If there is a relationship to be said, if you want to name your friend, then call him a friend. If you want to name your nephew, make sure this is my nephew, first, middle, and last, and make sure that it's understood who that person is. What we don't want to see is, class gifts to unidentified heirs. Oh, to my nieces and nephews. Great. Now we need to figure out who that is. That can be a problem. And that can also mean, an heirship hearing. You really don't want to do something like that. Name them properly. Full legal names and relationships are generally the best way to go. And we kind of already touched on this, how we handle property across state and national borders. If you've got real estate in a different state other than California, you should have an estate plan that governs, what's going to happen to that property. What you don't want to do is open yourself up to probate in two different states simply because you didn't have an estate plan that could cover both of them. And to be very clear with you, a revocable living trust, even if it's situs in California, can govern the distribution of property in Texas. And I have seen that happen. Basically, what you're doing is you're saying, I want this piece of property to go to X, or I want it to be liquidated and the proceeds sold. All of that is fine, okay? There's nothing wrong with that. What you don't want to do is get into some sort of situation where you are terming a piece of property with a characteristic that is not necessarily used in that state. So for example, Connecticut is not a community property state, California is. So if I am describing Connecticut real estate, as though it's community property, that's going to be meaningless to somebody in Connecticut, and it's going to be meaningless when it starts going through the litigation cycle as to how that should be treated. So again, if they don't have the same kind of property system, you're really going to want to make sure that your language is succinct for where that property is sited. And again, we talked about, property that spans national borders. If you have property that's in a different country, you need to have an estate plan that is built by somebody who is licensed in that country, okay? There is no way around that. And again, it's all because of the tax treaties or lack thereof between the US and the situs country. And so if any of you need referrals on something like that, just go ahead and click that QR code. I actually do have a lot of international estate planning attorneys. They're really great at what they do, and they'd be more than happy to help you. Next up, in terms of the grouping of questions. Oh, Jonathan's back again.
Yeah, one quick question about avoiding probate.
Sure.
Is there still an estate value below which it will not go to probate?
So in California, there is something called a small estate affidavit, okay? And it is typically $150,000 and below, and that's total, not per asset. That's like everything beneath that. So let's say that you were like me in law school, where it's like you were renting a room in somebody else's house. You maybe had a car, a late model. You maybe had $20,000 in a bank account, and you pass away. Okay. In that instance, you can use a small estate affidavit. You can go through the DMV to transfer the title on the car without having to go through court. And you can take that small estate affidavit, which is a notarized document, take that to the bank and empty out that bank account. Okay. So that would be a way to avoid probate in that sort of small estate arena.
Okay, thank you. And then just a clarification on beneficiaries. One patron asked, can a boyfriend or girlfriend be a beneficiary on life insurance or a retirement account? So I guess, yeah, who can be a beneficiary?
Anybody you want. Anybody you want. To my knowledge, I don't think that there are any federal restrictions on that. There may be I don't even know if there are restrictions on federal inmates. I think you can name pretty much anybody in the US as a beneficiary on any life insurance policy, any retirement account. There is nothing that says you have to name a family member. Do I think it's a wise idea to name a boyfriend or girlfriend? I think that, again, this is going to be really fact specific. That it's not that you can't name them, but if you break up and you don't change that, that's going to be a problem. And I think that there was a Reddit post that our office posted about where somebody had actually they had named their former spouse and then gotten remarried and forgot to change the beneficiary designation. And now the new spouse was pregnant. It was a total mess. And this woman was like, would I be the a-hole if I held on to the life insurance money? And of course, there's a huge debate about that because there's all sorts of moral and ethical implications. But I'm not saying that you can't do it. I wonder if you should. And that's, I guess, like the mom and me saying, hey, maybe don't do that. Maybe think about it before you do it. But, that's fine.
Great, thank you. And I just want to say to everyone, I know we're hitting 12 o'clock. Marlon has generously offered to stick around longer to finish answering all those pre-asked questions.
Yeah.
So if you do have to leave, don't worry. I'll send out an email later today with a recording of this so you can catch up on what you missed.
Right. We'll probably go for another 10 minutes and then we'll be done. But this next set of slides is a good one too when we start talking about fiduciaries, successors, and administrators. And again, when you're choosing your trustees, your executors, your agents under any documents, again, good financial acumen. They need to be able to find an adult if they don't know what to do. And they need to be able to handle a high stress situation. It's just super important that we do that because, again, you don't want somebody who's going to crumble under pressure. You don't want somebody who's got a substance abuse problem that this is really going to aggravate because now they're just really stressed out about dealing with it. Don't choose people that can't handle the stress. That's really the number one thing. And again, they have to have good financial acumen. In terms of compensation, though, most documents, at least the ones that we draft in our office, and a lot of the ones that I've seen have basically said that reasonable compensation is the order of the day in terms of trustees, executors, and agents. Executors is kind of a special category there because in California, the fee for your executor is actually set by the California statutes. It's statutory and it's based, again, on a percentage of the estate and can be tens of thousands of dollars, just like what you're paying your attorney. So do you want to avoid probate? I don't know if I've harped on this enough, but yes, you really do want to do that for that reason alone, because they can take quite a huge chunk of the money out of the estate in terms of compensation. They're legally capable of doing that. But again, your trustees and your agents, your documents should give them something, in my opinion, because the work that they're doing is not easy. It is stressful. It does take time out of their life. And so if they're not being compensated for it, there's a pretty good possibility that they might have some angst about it, maybe not do as good a job as they probably would if they were getting paid. So just be aware of that. You definitely want to make sure that if your trustees are managing a trust on behalf of your minor children, that they are compensated for doing that, because again, that's the fund for your kids if you pass away. What do you do if there are no friends or family available to manage that? That's a really great question. There are companies out there, private professional fiduciaries and corporate fiduciaries that will manage the distribution of your assets and the winding up of your affairs, whether that be through a trust or otherwise. They typically charge about 1 or 2% of the trust assets as part of their fee. But they do a really good job, and they are licensed to do that. And so you're paying for the expertise, basically. And I think that that's a really reasonable way of putting it. You're paying for the expertise. And again, professional fiduciaries or corporate trustees, in my opinion, and there's actually a list that's circulating, I want to say through the San Francisco Bar Association, a list of licensed professional fiduciaries. These are people that are not necessarily tried or tied to corporate banks or anything along those lines. They do this as their full-time job, and they manage quite a few trusts across the board. I find that they tend to be a lot more responsive to my clients because, again, they're just a smaller firm. They're licensed, so they're bonded, and they just do a good job. Not that corporate trustees don't, but corporate trustees like Chase or Bank of America or whoever, they have a tendency to be corporate and cold. And that may not be what you want for your trustees at the end of the day. So next up, let's talk about in the 5 minutes, maybe 6 minutes that we have, we're going to try to talk about tax strategy. This is going to be kind of a doozy, so we're going to be cramming a lot in the space of a single slide. And believe me when I tell you, we are not going to take a deep dive into this because we just don't have the time. First, let's talk about the estate, the basics of estate and inheritance tax. Currently, in California, and also in Texas, by the way, there is no such thing as an inheritance tax. Okay, so it's not like if you inherit something, you're going to be paying tax on that. That's not at all how it works in California or in Texas. That is not the case in other states, by the way. So just be mindful of that. If you do have beneficiaries who are out of state, this could be impactful to them. But in terms of estate tax, every single US person has $13.99 million of estate tax exemption attributable to them. And what does that mean? That means that you can die with $13.99 million of assets and never pay a dime to the federal government in terms of estate tax. That may change. Again, the tax package that was being voted on this week after Cory Booker's historic 24-hour filibuster, that may change completely. That limit, I think, is only going to go up because just who's in power right now. It also means that you have that same 13.99 million exemption in gift tax. That's actually a combined unified tax. So estate and gift sort of sit right over top of each other. So over the course of life and at death, that number stretches across them. So if you gave $12 million during the course of your life and 1.99 million when you passed away, you're still not paying anything in tax. Okay, then that's generally how it works. Between spouses, it's a little bit different. Spouses can have unlimited gifting both in life and at death. So that means that if you know that you have a taxable estate, let's say that each one of you is worth 15 million. That means that spouse one passes away and they can gift 15 million to their other spouse or to their spouse, and still not pay anything in tax, because once that gift is made, there's nothing in this estate to tax. Spouse two is going to have a pretty big problem on their hands because now they've got $30 million of assets sitting there and only 13.99 in exemption. So they're going to have to do some pretty strategic tax planning to get rid of some of that money out of their estate before they pass away. We talked a little bit about the step up in basis. And again, what that means is when you buy a piece of property at, let's say, X, and you pass away, it gets a step up in basis to X plus current market value, okay? So let's say, again, you bought a house for $10,000 and now it's worth $100,000. The step up is $90,000, okay? So just be aware that that's pretty much how they calculate that. And in terms of strategic planning with trust for asset protection or tax deferral, this is, again, a very fact-specific conversation to be had with an attorney who also is talking with your wealth manager and CPA. This is a team effort. And the reason why I say that is because the tax tail is wagging the dog on this conversation. This is not something that you DIY at all. Depending on what your financial modeling looks like with your wealth advisor, if you really do need something for tax deferral or asset protection, we need to figure out over the course of your lifetime what your retirement nest egg needs to look like, and whether or not we need to pad that with life insurance to pay your estate tax. So that's question number one. Question number two is, what kind of asset protection are we looking for and why? So we definitely need to have a conversation, again, with a CPA and your wealth manager to figure out what kind of strategic planning needs to happen. What's in your portfolio? Do you have a qualified small business that gives you qualified small business stock? That is a very specific asset under the tax code that has to be treated a very particular way in order for you to take advantage of the tax code. If you don't have a conversation with a CPA, you're not going to know that. Also, in terms of different varieties of assets, if you have, again, cryptocurrency is traded like a commodity. It's treated like a commodity under the tax code. It's not a currency. So just be aware that means it has very different tax implications. You want to be aware of capital gains tax, especially when it comes to appreciating assets. If you're a business owner, you definitely want to figure out, if you have an employee stock option plan, how that's going to fit into your tax mitigation strategy, and whether or not maybe placing that into, I don't know, an intentionally defective grantor trust in order to sell back the equity to your employees, however you want to do that. But again, these are really, really complicated conversations. They do require a deep dive, and it's unfortunately, thankfully, at the end of this slide, it's not something we're going to be able to go into in great detail right now. But again, click the QR code. If you have questions, if you have specific assets and you've got those kinds of problems, you are going to need to talk to somebody. So that kind of brings me to the end of the presentation, and we've got about 2 minutes left. that is my contact information. That is a really old picture of me. I clearly don't look like that anymore, but that is my email address, and that is our direct dial to the office. And if you have any questions, you can always click that QR code, or you can just call the office and make an appointment.
Thank you so much, Marlon. This was a great presentation, and I'm always blown away by how much you can cover in just over an hour. And thanks all of our participants for coming today. We received so many great questions ahead of time, and also some questions today. I know we didn't cover everything.
Yeah, it was impossible to.
Yeah, but and sometimes you know, when you have more specific circumstances and questions, which is common with estate planning, yeah, that's the kind of thing, as Marlon said, you might need to get some additional personalized advice on that. So, you know, if we didn't answer your questions today, like I said at the beginning, feel free to reach out to our department. We can try to connect you to information and resources, and also take advantage of Marlon's generous offer to follow up with folks after this this webinar today. So just a reminder, I will be sending out a follow-up email later today with a link to the recording of this program, a copy of the slideshow, as well as a very short evaluation survey, which please take a moment to fill that out. It only takes like a minute. It helps us improve our programs and plan future ones. So again, thank you all for joining us today. And Marlon, it's always a pleasure to have you. I hope we can have you back soon for another Ask a estate planning attorney.
Anytime for you guys.
Thank you so much. All right, everyone, enjoy the rest of your day. And oh, one thing I did want to plug, there was some questions about property transfers, and I do want to plug a program we're having next week, is on Prop 19. The San Francisco Assessor Recorder will be talking about how to do intergenerational wealth transfers. So I'll include a link to that in my follow-up email. And check out everything else we're offering in April. All right. Thanks, Marlon. Thanks, everyone.
Thank you so much. Have a great afternoon.